All right, so today is Tuesday, March 9th, and it is noon, and I'm speaking with Eric Bain regarding the Derek Chauvin trial that is taking place in downtown Minneapolis. So just to get formalities out of the way, Eric, if you just want to tell me who you are and what your background is in law.
Yeah, good morning. Thanks for having me. So I'm an attorney. I'm a solo practitioner. I own the firm Bain Law in Minneapolis. I've been a criminal defense attorney my whole career. I've been in practice, I think about going on 6 or 7 years now, and all in Minnesota.
Okay. So can you quick tell us what is going on with the case right now with Derek Chauvin downtown? There was a delay to the trial. There's something to do with third degree, the third degree that was somehow botched, or I don't know if that's the correct word for it, but fill us in on what's going on.
Sure. Yeah. So right now the trial is in the voir dire stage. It's
What does that mean?
commonly known as jury. Yeah. So it's jury selection. They're trying to go through a pool of people, residents of Hennepin County, and trying to find people that are fair and impartial, or at least say they can be fair and impartial, and that the lawyers in the court believes they're fair and impartial, to hear the case without any preconceived prejudice or notion. That's incredibly difficult with a case like this that's been all over the news, since it happened, and that video taken by the bystander that ricocheted around the internet and the world. I think that most people, especially in Hennepin County, have seen it. So they're going through this long process, and it's painstaking, and it's quite frankly kind of boring to watch a little bit, because it really doesn't have too much to do right now with the charges against Derek Chauvin. But it's a really, really, really important part of the process, because these are the 12 people that at the end of the trial will deliberate about whether or not the state has met its burden, whether or not the state has convinced them beyond a reasonable doubt of the charges against Derek Chauvin. It's commonly called jury selection. I think that's a little bit of a misnomer, because the lawyers don't actually get to pick which jurors they want. Instead, both sides get to use strikes to get rid of jurors they definitely don't want.
Okay.
And what happens at the end of the process is you're kind of left over with a group of people that didn't get struck. And so it's not really, hey, I want juror number 6, 7, 8. Instead, it's, I definitely don't want jurors 1, 3, and 5.
Got
That make sense?
it. Yeah, it does. Can you inform people, and we'll get to the delay of the trial as it's starting today, March 9th. Can you quick inform us on what happened with the third degree?
Well, it's still happening. It's a really unique situation. So Derek Chauvin was charged with second-degree murder, third-degree murder, and second-degree manslaughter. Mm-hmm. The third-degree murder charge was challenged by Chauvin's attorney, Eric Nelson, and early on in the process, during pretrial motions. And Judge Cahill agreed that the state could not proceed with the third-degree murder charge. So the judge basically dismissed the third-degree murder charge. It's interesting because third-degree murder has been, under scrutiny lately, because third-degree murder, the way lawyers have commonly understood it, is you have to do something that's dangerous to others and with a depraved mind. Those are some of the elements of the crime. Mm-hmm. And so the classic law school example of third-degree murder is some psycho just starts firing off a gun at a passing train.
Okay.
And just shooting indiscriminately at the train. This person is not targeting any one person on the train. He probably doesn't know who's even on the train. But that is incredibly dangerous and clearly with a depraved mind. What happened with the Mohammed Nawar case a couple of years back is relevant here, because Mohammed Nawar was the officer who was charged and found guilty by a jury of killing innocent person who called 911 for help.
Yes.
And he was convicted of third-degree murder. And a lot of lawyers, myself included, found that kind of strange, because in that case, he fired his gun at a person he thought was coming to attack him. And the jury found him guilty of that. And it struck myself and a lot of other lawyers as kind of strange, because there was no real evidence in the case that he had a depraved mind. He believed, and we can talk about whether or not that was reasonable or not, but he believed he was under attack. He wasn't out there trying to necessarily kill anybody. And secondly, he very clearly fired his gun at a single person. So he wasn't really, let's say, shooting indiscriminately or anything like that, just trying to harm anybody in his path. Certainly, some of these horrible mass shootings that have been in the news, that's probably a third-degree murder. They're just out there shooting anybody they can hit. It's horrible and tragic, but the difference is that those are inherently dangerous to others, a group of people, as opposed to more targeted at one person. And so in the Mohammed Nawar case, his lawyer appealed the third-degree murder charge, and the Court of Appeals, so in Minnesota there's the district courts, and then there's the Court of Appeals, and then there's the Supreme Court. And so in the Nawar case, the case has been decided by the Court of Appeals, but not yet by the Supreme Court. And so in the Derek Chauvin case, the lawyers are arguing, at what point does the Nawar decision become precedent for the Chauvin case?
Got
it. So that's one of the issues. And the idea of precedent is that, and just generally speaking in law, there's this common idea that past decisions by courts should be followed in the future. And that's for consistency. It's a concept called stare decisis. It's just so that we have predictability in the courts. We don't want judges going off on their own and just, making decisions based on necessarily, whether or not they agree with the law or not. The law is what it is. It's the judge's job to interpret and apply the law. And so one of the legal issues that's been coming up with the third-degree murder is, well, at what point is the Nawar decision precedent so that Judge Cahill in this case is bound by it? At what point does he have to, abide by the decision by the Court of Appeals?
And is that precedent?
So,
is that the same as arbitration?
No.
Okay.
Arbitration is a process for dispute resolution.
Got it.
And
Okay.
Precedent is a decision that a court makes that an appeals court makes that all other courts are supposed to follow.
Got it. Because I was thinking in terms of arbitration. Did it happen in the past? Can it be applied to now? But
yeah. Fair enough. And so there's a Court of Appeals decision on Nawar, but no Supreme Court decision.
Okay.
So the defense has been arguing there's no precedent here because the Supreme Court has not decided it yet. So therefore, Judge Cahill is not bound by the Nawar decision and is free to dismiss the third-degree murder charge. The prosecutors, the AG's team, the Attorney General's team, is arguing, of course it's precedent. It's a Minnesota Court of Appeals decision, and they made a decision, and the Supreme Court might make a different decision, but until it's overturned or overruled, of course there's precedent for it. So it's put Judge Cahill in kind of this, unique situation. It's more just a circumstance of timing than anything else, that there is this highly important case that's still winding its way through the system. That's the Noir case that greatly affects the Chauvin case.
And
it's,
so,
I suppose, a sad commentary or sad reality that, we have so many police shootings in Minnesota that, we can't even resolve the previous one before we move on to the next one in court. But,
exactly. Yeah.
Here we are.
And so that's what's still kind of in limbo, dare I say, correct?
A little bit. Judge Cahill said basically at the end of the day yesterday, look, we don't have any more guidance from the Court of Appeals on what to do, meaning should we halt the trial or should we carry on? So Judge Cahill said, and I think he probably got this right, saying, well, we're just going to keep pressing on until someone tells us otherwise. In a sense, that's highly unusual because appellate courts are not supposed to provide what's called advisory opinions. They're not, you can't just ask them, hey, what do I do here? Because I don't want to get appealed. They say, no. You make your decision, and if it's wrong, then it'll get appealed and it'll come to us. But you can't come to us prematurely. And that's kind of what Cahill is trying to do. And I appreciate him wanting to do that. I think he just is trying really hard to get this right. But at the same time, I don't think he has a choice because the Court of Appeals said, look, Judge Cahill, you were wrong to dismiss the third-degree murder charge. Noir says that it can apply in this case, and so you need to reinstate it.
Got it.
And I think that's kind of the end. That's kind of the end of that. But it creates a unique situation where this trial may go forward, on schedule, the Chauvin case, and then later on, I think oral arguments at the Supreme Court, Minnesota Supreme Court for the Noir case are scheduled for June. And so the Chauvin case will be done by then. We definitely won't have a Minnesota Supreme Court decision on Noir until after the Chauvin trial. And that could potentially, impact what Derek Chauvin can be convicted of in terms of the third-degree murder.
And with that being said, okay, so that kind of clears up what's going on with the third degree. I'm curious to know what exactly happened yesterday in the delay, if you can speak to that at all, and what is happening today.
Yeah, of course. So my understanding is that the delay was caused by this last-minute decision from the Court of Appeals. And it was a special decision from the Court of Appeals. They got this kind of last-minute appeal, and they said, yes, we will get you an answer before the trial of Chauvin starts on March 8th. So usually there's just a lot more time for the lawyers, for the court to digest an appellate court decision before you start a trial. The Court of Appeals issued their decision on Friday. Trial started on Monday. And so what happened yesterday is the defense said, look, we're ready to go. We're not trying to, delay anything. But at the same time, we have an obligation to our client, to Mr. Chauvin. We got to appeal this, and, we need some more clarity from the appellate courts. And the state was basically saying, yeah, we think that this whole trial should be delayed until we have this cleared up from the appellate courts. And there's some strategy there. So, some of the things they're saying, yes, they're totally right. Everyone wants this trial to just be done once. No one wants a mistrial. No one wants that.
Absolutely.
And so they are trying to keep the train moving without it going off the tracks, essentially. And Judge Cahill was hoping yesterday to get basically an advisory opinion from the Court of Appeals, trying to get more guidance or clarity on what to do. And frankly, he just didn't get it. And I don't know what the backroom conversations are on that. And so at the end of the day, Judge Cahill said, well, we got to keep the train moving, so we are going to proceed with jury selection, with the voir dire process, and unless someone tells me otherwise, which I think is probably the right call, because they've set aside 3 weeks for jury selection.
Yeah.
And, I get that the lawyers are saying, we need to know what the charges are because it informs our decisions in jury selection. But I think at the same time, the lawyers can still proceed with jury selection, knowing that the third-degree murder charge is probably going to be at issue, is probably going to be at play. And maybe the Court of Appeals will provide some more guidance or clarity to Judge Cahill in the next week or two before jury selection wraps up. But
Okay.
I think at the end of the day, they're probably just going to say, yeah, reinstate it. Derek Chauvin needs to be tried on the murder 3. End of story. What more do you want from us?
So he's being tried on murder 2, murder 3, and manslaughter 3, correct? Or 2?
Manslaughter 2. And the open question, I guess, kind of, is whether or not it'll be a murder 3 charge that gets presented to the jury. But I just kind of think at this point that the murder 3 charge most likely will proceed as a charge that gets presented to the jury based on the Court of Appeals decision in Noir. Now, I think that the jury got it wrong in Noir. I think that the Court of Appeals got it wrong in Noir, and I think Cahill got it right in dismissing the murder 3. But the Court of Appeals decision is, they're saying that it's precedential right now and that it should be applied. So, at the same time, if, Mohammed Noor was convicted of murder 3 and, that got presented to the jury, I think a fair argument can be made that that charge should also be presented to the jury in Chauvin's case as well.
So Chauvin has 3 charges, murder 2, murder 3, and manslaughter 2, correct?
Yeah, those are the big ones. Yep.
Okay. Just so people are clear on that. Well, and today... Sure. Sorry, go on.
No, go ahead.
Oh, so today is just the first day of jury selection. So they're going through with it. Judge Cahill is pushing forward.
Yeah, exactly. I mean, technically they started yesterday, but they didn't do much. So as part of the jury selection process, they sent out questionnaires to the whole jury pool and had them fill them out and send them back into the court. And the lawyers got copies of them before Monday. And there were I think I saw it was like 16 pages of questions. And those include all sorts of questions, including, where do you get your news from? Where do you shop? Things like that. They're trying to build a profile of each of these jurors to try to infer if these jurors have biases or prejudices one way or another in this type of case. And so yesterday, the lawyers agreed to get rid of, I think it was 16 of the 50 people that returned juror questionnaires, saying, yeah, we both agree that these people are probably not going to be fair and impartial. So they got something accomplished yesterday. Today they're going through a little bit more of the, nitty-gritty of voir dire, where they will be asking questions of individual jurors, asking them if they can be fair and impartial. And with each juror, there's kind of a battle, because if the juror shows some type of bias one way or the other, one side is going to want that person to stay on the jury, the defense or the state, and the other side is going to want that person off the jury.
Yeah.
So, if you're one of the lawyers and you want that person on the jury, you're going to be asking that person certain types of questions along the lines of, yeah, I know that you believe that, but can you set that aside and be fair and impartial in this case? And then the other side is going to ask that same person questions, to really try and ferret out whether or not they can be fair and impartial, and if they're telling the truth,
Yeah.
like questions along the lines of, how firmly do you believe this certain thing, how involved are you in this movement? Do you belong to any groups or, social media groups about this type of thing? How deep into this belief or worldview are you one way or another?
Yeah. Yeah.
And that's called that, so the lawyers have this kind of battle going on for each of the jurors over who they want and don't want on the jury trying to make their case.
Got it. Well, thank you so much for clarifying what's going on, what's been going on, and what could be proceeding going forward. And we'll check back in with you probably in the next few days if you have the time, Eric, to just kind of keep the people informed and keep us informed on what's going on. So thank you so much.
Absolutely. Thank you, Tucson. Appreciate everything you're doing.
All right. Talk to you later. Bye.
Take care. Bye.